Thanks, ladies and gentlemen, and welcome to Davies, Collison Cave, Singapore. We're very privileged this evening to have such an eminent speaker and also a good friend of the firm, Dan Altman. Dan Altman is a partner of Knobbe Martens. Dan's going to talk to us about this ever-growing issue that we're experiencing, and I think it's a sort of a worldwide phenomenon about patentability and the shrinking, I would say, of what constitutes patentable subject matter. So without further ado, I'd like you to welcome Dan Altman. Thank you, Dan.
Thanks, Matt. Yeah, so as Matt said, this is in fact a very hot topic, both in the United States and other countries. The topic of patent eligibility, it seems to be one of the ways that the strength of patents is swinging on a pendulum. And for the last several decades, the pendulum has been swinging toward ever greater patent strength. But there's a general sense, at least in the US, that pendulum has swung too far. And the courts in the US, starting at the top at the Supreme Court, felt that patents need to be brought back down to earth a little bit. And this area seems to be their primary mechanism at the court level to bring patents down to earth. This is the statute, Section 101, that tells you what you can get a patent for. And when you read the statute, it looks extremely broad. It doesn't talk about any exceptions. It just lists these things, process, machine, manufacture, composition, without stating any exceptions at all. And in fact, based on this statute, the courts had given, up until recently, a very broad interpretation of the statute. Having said that, the Supreme Court, even before this recent line of cases, had carved out these three different areas that are exceptions to patent eligibility. These are laws of nature, natural phenomena, and abstract ideas. So these date back to the first half of the 20th century, these exceptions. They're not new. In 1980, which was probably the high watermark, was the Diamond v. Chakrabarty case. That was the case where they determined that a microorganism that had been genetically engineered to eat up oil spills was patentable subject matter. And at that time, they said that, of course, it's patentable subject matter because anything under the sun made by man is patent eligible. Well, that high watermark is now much higher than the current level of the water for patent eligibility. In three successive years, each of those three exceptions that predated this line of cases had a Supreme Court case where they emphasized that it's not just abstract ideas, natural phenomena, natural laws, but it's a little bit broader than that. It's not just a narrow exception. So I'll talk about each of these three areas and explain the areas of technology where it's relevant. First, the background. What is the law as it stands today, at least as interpreted by the United States Patent and Trademark Office? The USPTO has this rubric, and the rubric is relatively simple. It's applying it that becomes complicated. So the starting point is the claim directed to a judicial exception? In other words, one of these three things, the natural law, product of nature, or abstract idea. And then if that is present, then you have to go to number two. And if one of those three things is present, then you have to look at the rest of the claim and decide, is there something more than the judicial exception present that's sufficient to transform it into something that is patent eligible? And the Supreme Court gave very little guidance in any of their three cases in terms of how to determine what it is that is something that is enough to transform the claim into something patent eligible. So even though these cases start in 2012 and here we are 2016 getting on to 2017, there's still a lot of uncertainty in this area. So the Patent Office has been slowly but surely releasing more guidelines. Some of the guidelines are based on actual case law. So the Federal Circuit, which is the appellate court just below the Supreme Court for patent cases, has decided a number of these cases. And the Patent Office has incorporated the guidance from the CAFC into their own guidelines for their examiners. But they've also made up stuff. And they just decided this is what we think. There's no judicial basis for it. There's no way to know whether a court would actually follow it, but because there was nothing in the case law, the PTO felt they have to give some guidance to their examiners, otherwise they're left with nothing. So here's this complicated flow chart. Really, I don't think it's worth going through at this point because it's in a sense those same two steps that I mentioned previously. First, is there a judicial exception present? And if so, try to determine if whatever else is in the claim is enough to make it patent eligible. So I'll start with natural laws. And I'm going in order of the Supreme Court cases. And natural laws, this was the Mayo v. Prometheus case. So I saw from getting people's business cards and greeting all of you that we have a wide variety of subject matters that are represented by the work that you do. Surprisingly, all of these different exceptions are relevant in all different technological areas. But of course, you can see this natural law arose in the context of this pharmaceutical claim. And that's mostly where it's going to arise, but you'd be surprised that it is not just limited to this area. It can pop up anywhere. And in my practice, even though, as Matt mentioned, my practice is mostly life science, I get all of these different exceptions popping up in my practice. So it's important to pay attention, even though it may be hard to understand the technology if it's not your area. But this is the claim that started the problem. The Supreme Court said that this claim here does not present patentable subject matter. And what they said is that this claim encompasses a natural law. Now, why they said that, I don't know. If I was going to look at the claim, I almost said in the abstract, but that probably is not the right word to use. But if I was going to look at the claim without knowing anything about what the Patent Office was doing and what the courts were doing, I would say natural law, what natural law? But that's not the way the Supreme Court looked at it. The way that the Supreme Court analyzed this claim, and I'll skip through a few slides by just keeping on this slide. The way they looked at it is there's a natural law that the level of this compound called 6-TG is correlated to the efficacy of the compound that was administered. So it's a natural law. You look for a particular metabolite in the blood, and by looking at that metabolite, it just naturally correlates with whether you've given enough, too little, or too much of a drug. So then the question is, since there is a natural law, and we know a natural law is an exception to patent eligibility, then you have to go to the second part of the test. And the second part of the test is there anything more than the natural law? And here the court said, well, there is something. There's administering a drug, and there's determining a level. So administering a drug, maybe the doctor gives a shot. Determining a level you've got to go to the laboratory and mix things together and evaluate how much 6-TG is by some sort of assay. But they said that's not good enough, because that's just at a really high level of generality. If you're going to try to figure out how this natural law is implemented, the natural law is a correlation between the amount of drug administered and the resulting metabolite. Essentially, that's what you have to do. It's just totally general. There's nothing specific about it. It's just what you do in order to determine this natural law. Therefore, this claim is not patent eligible. So, how do you deal with it now when that claim is a natural law? If you have an invention that involves determining a diagnosis based on the presence of a metabolite, the courts are going to call that a natural law, no matter what it is. And for a long time, what the Patent Office was doing was not granting any patents that are in that area. And the Patent Office has no basis for coming up with any other guidelines on this issue, so they made them up. And they only made them up recently. It was in May of this year. But since these guidelines came out, there's at least a way forward to get a patent in this area. And the most important one, I think, was this example 29. The USPTO has published a set of guidelines for each of these three areas. And the example 29 relates to natural laws, and they made up a claim around the idea of determining Julitis. And what the invention here is that there's a protein called Jul1. And if you measure Jul1, then if you have a certain amount of Jul1, then that means that the person has Julitis. And anti-Jul1 antibodies are one example of a way to determine the presence of Jul1 and therefore determine the presence of Julitis. And part of the hypothetical that the Patent Office gave is also that once you know the patient has Julitis, you can treat it by giving them topical vitamin D. Just rub vitamin D on the skin, and that can treat the Julitis. So now there are several exemplary claims that go along with this hypothetical. And claim 1, this is a method of detecting Jul1 in a patient. And now here's the method: obtaining the sample and detecting whether Jul1 is present. Does anyone, let me throw this out to you guys. Does anyone want to hazard a guess as to whether this claim is patent eligible? It doesn't matter whether you're right or wrong, just make a guess.
No.
So yeah, I could see why you'd say no, it's not patent eligible, but the way that the Patent Office analyzes this claim is there's no natural law recited in this claim, because the natural law is the correlation of Jul1 with Julitis. And this claim doesn't say anything about doing that. There's no correlation present at all. It's just detecting Jul1 in a patient. You obtain the plasma sample, and then you analyze it to determine how much Jul1 is in there. So this gives a way forward toward patent eligibility. And so in many cases where you have discovered a correlation between a particular metabolite or some presence of something in the blood and a disease state, this is a way forward. Now, of course, there's a problem. And there's a big problem, because most of these cases, the invention is that correlation. This claim doesn't recite the correlation, so it doesn't have a problem with patent eligibility, but it sure might have a problem with novelty or non-obviousness.
Dan,
Yeah.
what was actually performing instead of detecting?
So this is a hypothetical. It's a hypothetical from the patent office. They just made it up. So no one knows. It's just...
So it could be a person, literally, or it could be some sort of diagnostic equipment?
You mean the detecting step?
Correct.
Yeah, when I think about this, detecting by detecting the antibody, that's probably done on a desktop chemistry type set. You know, it's not that difficult an assay to carry out. Many ways to do that. So the issue is this claim novel? And if so, is it non-obvious? Now, under these facts that the patent office gave, you can imagine a situation where this is non-obvious because perhaps Joule 1 wasn't even known. If Joule 1 wasn't even known to exist, then this would be a good claim. No patent eligibility problem and no prior art problem. But you can run into several problems where if Joule 1 was known and detecting it using an anti-Joule 1 antibody, that's not particularly interesting. So oftentimes you trade one problem for another, but hopefully if this is the route you want to go, there's something else you can add to the claim to give it some patentability over the prior art.
Sorry, Dan, wasn't that the problem with Prometheus? Because 6TG was known to treat the disease already, so the discovery was in the change in the metabolite over time.
That's one way to look at it.
Yeah.
But and what I think is really interesting is that in many ways, Prometheus' claim is almost exactly the Jouleitis claim that I just had up, because the only two real steps are administering and determining. These other things are just wear-ins. There's nothing really happening. But so if you took out the wear-in clauses, which have the statement of the natural law, you wouldn't have a patent eligibility problem, but you'd have a prior art problem for the reasons you mentioned. Now here's another claim, Claim 2. Exactly the same as Claim 1. The preamble is a little different, diagnosing Jouleitis, and now you actually diagnose. You recite the natural law. So, do you know where this one's going? This one's not patent eligible because it's very peculiar also, because when you think about it, Claim 2 could have been written as in the form of dependent on Claim 1. So you have a patent eligible claim, and now you have a dependent claim, which is narrower, and now it's no longer patent eligible. But that's what the patent office says. No court has ever said this, but that's what the patent office says. So you can get these claims from the Claim 1 from the patent office. Claim 3, this one looks just like Claim 2. Again, Claim 3 could be dependent on Claim 2, but now you're adding that it's a porcine antibody. So maybe there's something really interesting about the porcine antibody. Maybe the porcine antibody is particularly sensitive, or it does something where it binds to the Joule 1 very tightly and therefore makes the assay work more effectively. Now it's both non-obvious because it's something that wasn't known in the prior art, and it's also patent eligible because it's something that's significantly more than just the diagnosis step itself. So it's peculiar. Claim 1, the broadest claim, patent eligible. Claim 2 gets a little narrower, not patent eligible, and now it's a little narrower still, and maybe it becomes patent eligible again. Now Claim 5, this is another technique that we sometimes use to make a method of diagnosis into a patent eligible method. So here what we've done is, rather than specifying the type of antibody, we're saying, okay, we're going to determine that someone has Jouleitis, and then based on the results of that assay, treat them. And here, we're treating them with an effective amount of topical vitamin D. Now the treating step, that's not a natural law. in Prometheus itself, they said treating is an application of a natural law that is transformative. So there shouldn't be a patent eligibility problem for this claim because it recites the treating step. Having said that, in the real world, what the Patent Office is doing, if you presented the claim like this, instead of saying administering topical vitamin D, you say treating the patient for Julitis, or using known techniques for treating the patient with Julitis. That is not only not going to add anything to distinguish over the prior art, but it's not going to add sufficient information to make it patent eligible either. So the reason this works is that it's a specific treatment. And so that's why when you're drafting claims and drafting a specification for a medical diagnostic invention, you want to include specific treatments. Of course, most PCT applications that were drafted 2.5 years ago don't have them in there. Usually there's some general idea of treatment, but not a specific treatment like this. And so it's not an option if it's not in the specification. So it's a good drafting tip to think about treatment options that are sufficiently specific to lend patent eligibility. In this area, there's been a small amount of case law from the Federal Circuit, the CAFC. Not a lot of case law, but at least a little. And this is the first important case. There were a few other cases that were not very surprising at all. But this case, the Ariosa v. Sequinome case, was last year. And it was actually a very important invention. And I think that most of us thought that the courts would find a way to find patent eligibility here, but they didn't. And the idea here is that the patentee had a very clever way of conducting an assay that would essentially replace an amniocentesis. So that rather than having to stick a needle into the mother's womb, they could just conduct this assay on the blood from the mother. So it's an important invention. You know, there's significant risk associated with amniocentesis. And it was a very clever invention. They were able to identify specific types of DNA that they knew were DNA molecules from the father. So they knew that they were paternally inherited. So it seemed like it was something specific, a specific type of assay that ought to have been patent eligible, but that's not what the CAFC did here. Instead, they said that when they looked at the Supreme Court decision in Prometheus, they thought that Prometheus required them to find this patent ineligible, because all they did in the claim recited amplifying, which is a routine step, and then detecting the presence of this paternally inherited DNA in the amplified material. That's also routine. So even though it's an important invention, even though they were doing something that wasn't being done in the past, it was too much just a natural law and applying general steps to it. So the CAFC said, nope, it's not patent eligible. It was very depressing for those of us who are representing clients with patents in this area, but there you have it. Very recently was the Cells Direct decision, and this one, fortunately, came out the other way. So here, the invention was directed to a method of preserving liver cells, hepatocytes. And what they did is they exposed the liver cells to multiple cycles of freezing and thawing. And at first blush, it doesn't even seem to implement a natural law, but the trial court looked at it differently. They said that's just a natural law. So here the natural law is that hepatocytes are capable of surviving multiple freeze-thaw cycles. And that's all they did was implement that natural law. But you can see that that's quite different than these medical diagnostic claims. And the Federal Circuit said, look, the Supreme Court told us about medical diagnostic claims, that those are natural law, and we're going to follow that. But we're not going to expand that idea into other areas like this, which they considered to be a useful laboratory technique. So finally, a case that supports us, at least those of us who are in favor of granting patents to this inventions in this area. So what's the takeaway for natural laws? There was a time when it seemed like it was virtually impossible to get a claim to a medical diagnostic, but that's not true. It's definitely there are possibility. If you have unconventional steps in the assay itself, that's a good way. That's claim 3 from my example. Unconventional equipment or unconventional steps. The trouble is that many of these inventions, the invention really isn't in the way that you carry out the assay. It's what the result is. So it's this correlation between Joule 1 and Jouleitis. That's the invention. And if that's what your invention is, you've got to come up with another strategy than just claiming that invention. So either adding the unconventional steps, or leaving out the natural law and putting something else in entirely, or perhaps combining diagnosing and treating steps. Every case has to be looked at individually, but there is usually a way forward. And it's quite helpful to think about this when you're drafting your case, because then you at least have some ammunition to fight with the patent office on. The hardest cases are the cases that were filed before 2012. So the next area is natural products. And this came about because of the Myriad decision. And Myriad involved the patentability of DNA. And since that Chakrabarty case that we talked about early on, the 1980 case, everyone assumed that even though DNA occurs in nature, that as long as you said it's isolated DNA, you snipped out the particular DNA that codes for something, that was sufficient to make it not a product of nature and therefore patent eligible. But in the Myriad case, the Supreme Court held no, that's not sufficient. So just saying that something that's found in nature and isolating it from the chromosome is not significantly different. So they followed the same reasoning, that there is a judicial exception present, it's the natural law. And then they said, well, look, it's the same genetic information. It's essentially the same molecule. Just calling it isolated isn't sufficient. It's not significantly different. Now, strangely, they looked at something called cDNA. And for those of you who don't work in biotech, cDNA is almost exactly the same as a DNA, except it's the RNA version. It's the DNA version of an RNA. So it's almost exactly the same as the isolated DNA, but there are little pieces of DNA that are missing, because when you turn the DNA into RNA and then turn it back into DNA, the structure has changed a little bit. Some of the pieces of the DNA are missing. So the Supreme Court said, well, that doesn't occur in nature. A DNA that has these pieces missing doesn't occur in nature. An RNA that has the pieces missing, that does occur in nature, so that's not patent eligible. But because this is structurally different, And it's a very minor structural difference. There's a hydroxyl substituted for hydrogen. That's the difference between DNA and RNA. Other than that, they're exactly the same. But paradoxically, cDNA was held to be patent eligible. The Australian Supreme Court also looked at this. And several of you here are Australian patent attorneys, will know far better than I, but they did not make this distinction in Australia. So at least it gives a little bit of room to find something patent eligible in the US. And in fact, the US guidelines are very generous. The patent office really only looks at the only difference between something found in nature and what's claimed as the word isolated, that's not good enough. But almost any other difference will be patent eligible. So it's relatively easy to find something that you can claim about the natural product. So if you put the natural product in a composition of matter, where you mix it in with certain excipients or things that are necessary to deliver that composition, that's typically all you need. And I think the reason why the Patent Office is looking at this fairly generously is the Supreme Court was pretty generous when they said cDNA, it's got this trivial distinction from regular DNA, but that's good enough. And so, at least in products of nature, the courts are, or there haven't been very many court cases, the Patent Office is rather generous. One area that's a little bit interesting, and this is the one area that it's hard to figure out how it's going to come out, is admixtures of natural products. So if you have two things that both occur in nature, they don't occur together, but you mix them together, then the question of whether that is patentable really depends on what you said in the specification. It's really quite strange. So the guidelines have these two examples. And this is an actual case from many years ago. An inoculant for leguminous plants. These are like soybeans and nitrogen-fixing plants. And it's mixing together several species of bacteria. And the several species of bacteria hadn't been mixed together before, but the courts decided that this is not patent eligible because there's no markedly different characteristics for this mixture. But then, if you look at number two is essentially the same claim. Maybe it's a little narrower because now it talks about two specific species of rhizobium. When you look to the specification, that's how you determine that this claim is patent eligible. Because the specification says that when you mix these two strains together, these two strains can infect plants that either strain alone can't. So that's a markedly different characteristic. And so the patentability of this type of claim, the patent eligibility that is, depends on whether the specification provides evidence that something interesting happens when you mix the things together. So it's a little bit peculiar. You can't tell just by looking at the claim itself whether it's patent eligible. You have to dig deeper. Abstract ideas is probably the area that there's been the most case law, and therefore there's at least some guideline from the courts in addition to what the Patent Office is doing to help you figure out what might be patent eligible. The starting point for this was the Alice decision, and there's Alice, she's killing all those patents. The difficulty with Alice was that it was an invention that computerizes something that's generally known as settlement risk. So, when you buy something on eBay or whatever the Singapore version of that is. So the problem is you don't know the guy who's selling whatever it is you want, and that guy doesn't know you. So who should go first? Should the person pay the money and then get the product? Or should the product be shipped and then pay the money? And so neither side really trusts each other. And so in the real world, what people sometimes do in this situation is they use an escrow in the middle. Say, okay, well, you give the money and you give the product, and then when the escrow agent gets both, he ships the money one way and the product the other way. In a sense, that's what the Alice invention was. It was a way to do that on a computer by creating these shadow records. So CLS wanted to enforce its patent, and they just went through the exact same analysis as in those biotech areas. They said, is there a judicial exception? They said, yes, it's an abstract idea. And then, is it significantly more than the abstract idea? And just sticking the same process on a general purpose computer was considered not enough to render the invention patent eligible.
Yeah, just a quick question.
Yeah.
You skipped over it very quickly. Why is it an abstract idea?
Why is it an abstract idea?
The claim would not have been an abstract concept for doing this. It would have been a reduction of the practice of the concept. So why does it immediately become an abstract idea?
Well, I can give you some circular reasoning on that. There's a slide on that. And so what the patent office and the courts have determined is an abstract idea, because of course abstract idea is a label. And if you think about it, is it really abstract? No, something's really going on. But the way that the courts have looked at this is they've categorized certain things into abstract ideas. And one of the things that's an abstract idea is certain methods of human interaction. And so if it's going on at a computer, it's necessarily abstract. That's the way that the courts are looking at it. Now, so you have to put logic away. You can't just look at abstract idea and say that's an abstract idea. Just like you can't, in the Prometheus case, say there's a natural law there. It's a common law system, and therefore once the court says it's an abstract idea, that's one data point. This is an abstract idea. So that's why the answer is necessarily circular, because you have to go to the courts and the case law to determine what abstract idea is. And the Supreme Court recognized what they were doing here. They said we must tread carefully, otherwise it will swallow all of patent law. And for a little while it looked like that's actually what was going to happen. But I think they've fallen back from that particular abyss. There is a little bit of an abyss, though. It might be hard to see from the back. There are certain art units where the allowance rate approaches 0. And that's especially in here. These are the e-commerce fields. And so this is the rate of rejection. Before Alice, the rate of rejection, this is only for patent eligibility. So even before Alice, you could see there were significant levels. I don't know if you can see the numbers from in back, but after Alice, the numbers really got high in terms of the percentage of cases that get through this patent eligibility roadblock. And this is e-commerce. I was talking when we were chatting before the presentation, and you do not want your patent application, at least if you want to get a patent, to go to the art unit that examines these, because the likelihood that you're going to get a patent anytime soon is extremely low. You can see these numbers are all above 90% rejection. So usually when you have an invention that relates to e-commerce, there's something that's happening in the real world as well. And if it's something that has to do with how the computer works, or something that has to do with a transaction that's actually being carried out, something that is clearly not abstract, what you want to do is hide the ball a little bit. Because when you file a patent application, there is an office called OIP, Office of Initial Patent Examination. And there are people in there, these are low-level patent office employees, but they are trained to identify what particular technology the invention belongs to. And in general, the parts of the application they look at are the title, the field of invention, the abstract, the preamble of the first claim. Those are the most important things. And so if those things say e-commerce anywhere or financial transaction on a computer, that's essentially the same thing as saying I don't want a patent. So take those things, if you do want a patent, take those things out of the title. Take them out of the field of invention, the abstract.
It's a good practice in general for drafting patent specifications. You have claim 1. The preamble of claim 1 is typically the title. The abstract, at least from an Australian point of view, was always effectively a carbon copy of claim 1. So you're suggesting that for future, if you've got a financial transaction system, for example, claim 1 should be a method of building a house. And claim 2 should be the financial transaction system.
Yeah, well, I mean, if the method of building the house is, if it's going to look totally different than claim 2, they're probably going to look to claim 2 to figure out what is this. So it's got to be something that's related to what the invention really is. So if it's something that involves a financial transaction that's used when you're financing the house and then you're going to build the house, then yes, have the claim be a method of building a house rather than a method of financing a house. Because if it's a method of financing a house and then there's a general purpose computer recited, it's going to get into this red zone. The thought is, well, if you do have a business method, can you just take it to the Patent Trial and Appeal Board and take care of it that way? And unfortunately, we still have a pretty high rejection rate. It's 86%. So the PTAB, that's the appeal board in the US, they're not particularly friendly to this e-commerce field either. So again, this isn't the place to go if you can avoid it. And the courts themselves, when you look at all the court cases, and there have been a lot of court cases in this area, they're very often finding claims invalid. And the district court, that's where the trial occurs, those are found invalid 63% of the time, but the cases that have actually gone up to appeal, 91% of the time the federal circuit is saying these claims aren't valid. So it's a very difficult situation if you have e-commerce in particular. But this involves any rejection under Section 101. The courts aren't very friendly. So this is now back to Ross's question. How do we know what an abstract idea is? Well, this is what the Patent Office tells us is an abstract idea. And you have to put away your conception of what abstract idea means, and instead of using your own sense of what abstract idea is, go to what the courts and the Patent Office say an abstract idea is. So a fundamental economic process, which was Alice, that's an abstract idea. And then here's one that's so clear and so helpful. Certain methods of organizing human activity, it tells you exactly what it means, doesn't it? An idea of itself, that one you can sort of understand. And mathematical relationships, that's just a pure algorithm. So what are some fundamental economic processes? And this is some of the cases tell us what these are. Agreements between people, performance of financial transaction, mitigating risk. There are cases behind every one of these examples. So these are all fundamental economic processes, and they're considered abstract ideas at the Patent Office and by most of the courts as well. Now here's this model of clarity, the certain methods of organizing activity. The Patent Office guidelines tell us what they mean by certain in quotation marks. I'm not sure that this helps us that much, but interpersonal and intrapersonal activities, managing relationships, transactions between people, social activities, sales activities, managing mental activity, what's going on in here, those all qualify as certain, whatever that is. It's clear that not all methods of organizing human activity are abstract idea, but there's not a lot of clarity here. So what you really have to do when something falls into this area is go to the case law and try to figure out which cases your particular case looks like. And if you want a patent, you want to find a case that found a claim like your claim to be patent eligible. They did specifically mention in the guidelines that this certain methods doesn't cover a human operating a machine. So if you have a human throwing things in a clothes dryer as part of your claim, at least that part's not going to be considered an abstract idea. Playing bingo on a computer. This was an example of the certain methods that is considered an abstract idea. Is bingo played here? Yeah. Okay. An idea of itself. Here's an example of that. This is a computer-implemented method of resizing textual information. So when you're reading your Kindle and you want to, you're having trouble with seeing these little letters, and you say, okay, let's put a bigger font in there. That's essentially what this is trying. It's a way of allowing a computer to do that. And this claim was considered to be an idea of itself, because nothing's really happening. The idea is set forth. What you want to do is set forth, and what you want to do is take the little font and make it a big font. But it doesn't actually carry that out. The claim doesn't say displaying a tiny font and then going through all this stuff and then displaying a big font. It is just the idea itself. And so therefore this claim is so far away from patent eligible that they're not even going to look into it. And the fact that it says computer implemented, that doesn't make it more than an idea of itself. Mathematical relationships and formulas. There are a lot of examples of this. I think it was accepted even before this line of cases that if Einstein developed E equals mc squared, and he says, I claim E equals mc squared, everyone would have agreed that's just an abstract idea. There's nothing to it. But what if he had claimed, I claim a method of determining the rate of fission of fissionable material, and I use this equation in it. Now you're going to end up in this little bit of milieu. Is that significantly more? No one really knows. It's very difficult to determine. But if there is a mathematical formula recited, then you're going to end up in the situation that there is an abstract idea and you've got to point to significantly more. There were a few cases recently that have been helpful to those who want to obtain patents in this area. One recent case, all these cases were in the last month or two. EnFish was an important case. They're claiming a specific type of data structure. And so the data structure in the computer itself. And here, using that data structure allowed the computer to carry out its functions in a way that worked better than prior art data structures did. And so here, even though it's only inside a computer, it's a bunch of dits and dots inside the computer, the court held this isn't even an abstract idea, because it is something that improves the way the computer works, and therefore it's not an abstract idea. It's just dedicated to the computer technology itself, and that's not abstract. So EnFish tells you that if you can find a way to argue that what your claim is not an abstract idea, boy, you're 2 steps ahead in the game, because then you don't have to go to the step 2, which says, well, I've got more than the abstract idea. But in order to do that, you have to rely on all these cases that have come before and say, okay, my claim is like EnFish's claim because I've got a data structure. If you don't have a data structure, my claim is like EnFish's claim because it's something that helps the computer itself operate more efficiently, and therefore it's not an abstract idea. But so there's room here in all of these decisions. Mickrow is another case where the claim was held to be patent eligible. This is also September-October timeframe, very recently. And here's a cool idea. It's lip syncing. And when you lip sync, most of us aren't really as good at it as we think. If you've got a video and you want to sync up your lips to the music that's going on in the background, and doing that without a computer is very difficult because someone has to sing, and then you have to make the music go at the right pace. What this invention does is you videotape yourself at least making a mild attempt at lip syncing, and it will speed up or slow down the music so that it matches your lips. And here, it seems like it's kind of abstract, but in this case it wasn't. Because the way that the CAFC characterized this is that there was this previously subjective process. So in the past, someone had to manually speed up or slow down the music to match the lips, and now the computer is automating it. And automating this previously subjective process was considered not to be an abstract idea. So again, it provides you with another rationale for arguing that you don't have an abstract idea. Bascom. Bascom said that filtering content. So what they've got, they had claims directed to a system for filtering content from the internet. So in other words, there's all this stuff on there, and this system would find the particular content that you're looking for. Filtering of the content, that's an abstract idea. So there's not much you can do about that. The additional elements, the generic computer, the internet components, those aren't going to do much for you. But there's a but here. And what this claim had that saved it was that it had a unique arrangement of these known conventional ideas. So the generic computer network, the internet components, the way that they arranged and the way that they related to each other, that was novel and it was unconventional. And therefore, the claim here, you had to go all the way through all this to find it patent eligible. Amdocs, this was a very peculiar case. This was from last month. And what the CAFC did here, they basically punted. Is that a phrase that means anything here? Well, in American football, at least, you punt when you say, I'm out of options here, I'm just going to punt and give the ball back to the other side. So that's what the CAFC did here. They said, we don't really know whether this claim is patent eligible or not. So what they did is they dusted off all of their decisions of the last 3 years. And they said, when we look at all these cases, the claim here looks most like the claims that we held to be patent eligible, and it looks less like the claims that we held to be patent ineligible, and therefore we're going to find the claim patent eligible. So that's why it's characterized as the common law approach. You just, this base law has developed of several cases, and the claims look more like the cases that are patent eligible. And so unfortunately, that's what this area seems to be heading to, is that we're getting this body of case law, and the claims that look like the body of case law that is patent eligible just adds to that body of case law of patent eligible. It can be used the next time. So as this law develops, there's more and more to work with. So the case law is more important in this area than just about anywhere. And the Patent Office has recognized that. They're compiling these decisions and creating guidelines every few months or so in this area. So even though there's not a lot of logic behind what's patent eligible and what's not patent eligible, there are a lot of examples, and that's really what you're going to be doing. And then there's another recent case. This one was just a couple weeks ago. This one went the other way. And again, they're saying, well, compared to EnFish, it's not really related to improving the function of the computer. This case is electric power group. It was, instead of improving the function of a computer, it was improving the function of an electric power grid, which is something that the computer controls. And so that's not the same as EnFish, so that's not going to be helpful. And there was no inventive concept in the arrangement of these abstract features, so it's not like Bascom, and therefore it's patent ineligible. This claim, this case, I think it's important because Judge Meyer, he's been giving in all of the recent cases, he has either been concurring if the case went the way he likes it, or giving a dissent with this First Amendment idea. And Judge Meyer thinks that patents shouldn't be granted for computer-related inventions. And so every time he's on a panel where this issue arises, he puts this First Amendment thing in. And he says that, that when you grant a patent on a computer-related invention, that people who want to use that invention are now forbidden from doing so because there's this patent, and their First Amendment, in other words, their freedom of speech rights, are abridged. It seems to me a bit hyperbolic. But Judge Meyer, if you have a computer-related invention and he's on your panel, you're going to be a little bit concerned because you got one vote against you even before you present your case. So what's the conclusion of all of this? Patent eligibility 4 years ago was considered broad, extremely broad. Now there's a lot of hurdles to get through. Most of the time, there's a way to claim an invention. The abstract idea area has the most case law, but is perhaps the most difficult to navigate your way through because the courts and the patent office seem to be using this common law approach. You know, which cases is your case most like? So it's very difficult. But requires careful claim drafting as well as careful specification drafting so that you have backup positions that you can use. If you don't have the backup positions in your specification, you may not get a patent. There's not much you can do then. And even though there has been some case law, it's still evolving. There's probably going to be some big new case that changes this procedure in a very dramatic way, but so far that's not what we're seeing. We're seeing nibbling around the edges. So it's a very important developing area in US patent law, and we have to keep watching this space.
What's your feeling as to where it's going to go in the next sort of 4 to 5? Because we're filing patent applications today in view of the recent case law that we're looking at. But it's taken 4 years to completely change and then to start swinging back again. It's very hard as a practitioner to look into the future and attempt to future-proof the applications themselves.
Well, this is true. I think it's a little bit better today than it was 3 or 4 years ago when there was no case law and we had no idea what type of things that the courts were looking at. But I think one of the things in the computer area that the courts seem to like a lot is that if you've improved how the computer works itself, that seems to be something that it's not even an abstract idea and saves you a lot of trouble. So now courts might fall away from that, but it's always a good idea to include an angle in that regard. I've known that my predictive powers are really bad because courts just do what they want, as do voters.
Is there any other questions for Dan?
You mentioned that DNA has to be significantly different from what exists naturally. So can't it be raised under a novelty objection rather than having eligibility issue?
Oh, well, why isn't it a novelty issue?
Or is it considered in court as a novelty issue?
It's not. It should be. I mean, when all of this really could have been done under the prior art, but that's not the way the court decided to analyze it. They decided to mix this up by saying, if it's a sequence that occurs in nature, and all you've done is isolate it, then it's not patent eligible. Now, if it's a sequence that doesn't occur in nature, then it's patent eligible. So it's not analyzed under novelty, even though it could be. Because the isolated DNA, that's novel. It's never been isolated before. It only existed in the chromosome.
So you also mentioned that it's quite easy to overcome this issue, right? To have something that's different. But what are the things that will be sufficient? Do they consider structure?
So if you have one nucleotide that's different in the sequence compared to the prior art, that would be considered something that doesn't occur in nature and therefore it's patent eligible. If you have a protein, for example, a polypeptide, if that polypeptide has carbohydrates on it that are different than occur in nature, that would be sufficient. So any minimal structural difference is considered sufficient to overcome patent eligibility problems.
Yeah, I mean, thanks a lot, Dennis. It's really good to discuss because I think it is a very much an evolving landscape. I think one of the challenges I face, and probably you guys as well, in drafting, is that you're often drafting for more than one jurisdiction at the same time. And despite TRIPS, despite other international agreements, Europe and the US are significantly diverging from each other now in what you can get and what you can't get and what you need to be careful with in your drafting and your specification. So I take your last point very carefully, although for me it's not so much about the claims, it's about now having these massive detailed descriptions where you have every option for the US when you go in and every option for Europe, because you're going to face different objections and different challenges that you need to grapple with in a changing environment as well.
Yeah, I was about to say that Europe seems to be more settled than the US, but of course that could change instantaneously.
Yeah, well, we have the tomato and the broccoli case that is causing cherry picking in the US, which is in Europe, which is a real problem for biotech inventions. So, but it's different to the US challenges, so this is quite hard for us when we're drafting.
You have to address both, that's right. Yeah. Yeah. They're not making it easier.
No.
I have a question.
Yeah.
Just like for natural law, you mentioned that one way under US is to add a treating step. So for countries that don't allow method of treatment claims, is there a way to get around the problem?
Well, this problem that I've discussed is a US problem. So there may be a problem in other countries, but the medical treatment isn't the way around it. Australia maybe, because Australia allows medical treatment. But I think US and Australia are the only countries that do that. But of course, this patent eligibility question is going to be analyzed quite differently in other jurisdictions.
So I'm just wondering, for applicants with this sort of invention, then I suppose they will file PCT applications. Would that be right? So you have specifications drafted for different countries?
Yeah, this is the problem that Becky just brought up, which is that you have to address all of those jurisdictions when you file your PCT application, and it's not easy.
Can I pose a scenario to you, Dan?
Yeah.
So you're a pharma company, and you've got some medicinal chemists, and they synthetically produce a small molecule, and they patent that, and it's ticks the box into patent eligibility. It's a synthetic molecule. 10 years into the life cycle of the patent, it's happened to, from a natural products chemist, finds the same molecule in a plant.
I would say they've got a very good invalidity argument, because even though the patent office didn't know it was a natural product, it indeed was. And so even though the patent was granted, a very good case could be made that it's not patent eligible. There are some peculiar cases, old cases, where they talk about trivial amounts of a product existing in nature as prior art. There was an old case where the court held that a claim was invalid because the patent was to a particular crystal structure of a drug. And this crystal structure could occur naturally at a level of 1 part in a billion. And so now, several years later, the company invents this crystal structure, and now they've got relatively pure crystal structure. But the claim was invalidated because in the prior art, 1 part in a billion they were able to prove existed in the prior art. So just this trivial occurrence, at least there's some precedence for the idea that a trivial amount is sufficient.
Thanks very much to Dan.